Get ready for the dictation. Start. This court in state of West Bengal and others versus Swapna Kumar Guha and others had the occasion to deal with this issue. Y.V. Chandrachud, the learned Chief Justice, speaking for three-judge bench, laid down the following principle. Whether an offence has been disclosed or not must necessarily depend on the facts and circumstances of each particular case. If, on a consideration of the relevant materials, the court is satisfied that an offence is disclosed, the court will normally not interfere with the investigation into the offence and will generally allow the investigation in the offence to be completed for collecting materials for proving the offence. The condition precedent to the commencement of investigation under section 157 of the code is that the FIR must disclose prima facie that a cognizable offence has been committed. It is wrong to suppose that the police have an unfettered discretion to commence investigation under section 157 of the code. Their right of inquiry is conditioned by the existence of reason to suspect the commission of a cognizable offence, and they cannot reasonably have reason so to suspect unless the FIR prima facie discloses the commission of such offence. If that condition is satisfied, the investigation must go on. The court has then no power to stop the investigation, for to do so would be to trench upon the lawful power of the police to investigate into cognizable offences. Keeping in view the aforesaid principle of law, which was consistently followed by this court in later years, and on perusing the impugned judgment, we are constrained to observe that the High Court, without any justifiable reason, devoted 89 pages judgment to examine the aforesaid question and then came to a conclusion that some part of the FIR in question is bad in law because it does not disclose any cognizable offence against any of the accused persons, whereas only a part of the FIR is good which discloses a prima facie case against the accused persons, and hence it needs further investigation to that extent in accordance with law. In doing so, the High Court, in our view, virtually decided all the issues arising out of the case, like an investigating authority or oblique and appellate authority decides, by little realizing that it was exercising its inherent jurisdiction under section 482 of the code at this stage. The High Court, in our view, failed to see the extent of its jurisdiction which it possesses to exercise while examining the legality of any FIR complaining commission of several cognizable offences by accused persons. In order to examine as to whether the factual contents of the FIR disclose any prima facie cognizable offences or not, the High Court cannot act like an investigating agency, and nor can exercise the powers like an appellate court. The question, in our opinion, was required to be examined keeping in view the contents of the FIR and prima facie material, if any, requiring no proof. At this stage, the High Court could not appreciate the evidence nor could draw its own inferences from the contents of the FIR and the material relied on. It was more so when the material relied on was disputed by the complainants and vice versa. In such a situation, it becomes the job of the investigating authority at such stage to probe and then of the court to examine the questions once the charge sheet is filed along with such material as to how far and to what extent reliance can be placed upon such material. Stop.